Studio Ray is offering today a new discussion. A lot of cases have been identified as classified, and many criminal cases were hidden from our society because of this, and a lot of policemen who, because of different administration or other faults or crimes, as publicly says Ministry of Internal Affairs, were fired from police service, and their IDs are still unknown to our societies as their crimes or administration faults. And now we can remember about several specific criminal cases. For example, Enveri case, Vakhtang Maisaya case, one of the first cases which was identified as classified. And there are many other criminal cases, and this process were named as classified justice, and today we will talk about this classification of justice, secrecy of justice, and whether it's dangerous to justice, transparency, I mean the methods and ways our justice bodies and parliamentary members offer our society. So journalist Tamar Gurchiani and human rights priority Mukhashavria, ex-political prisoners for human rights Gela Nikolaishvili, and Tskriala Shermadini, journalist from Studio Monitor, and the head of the studio room, Mamuka Kuparadze. Thank you very much that you came here to our studio to talk about this issue, and I'm sure that today our society will get more information from you, and it would be more important if we talked about general principles and about how our society should overcome this issue. The topic of the discussion was generated by Studio Red, that's why I want to ask Mamuka Kuparadze to open this discussion. Thank you very much. As you will know, of course, we have today more and more classified topics. I mean, people are arrested, and unfortunately we don't know about the reason for their arrest, and talking about intra-departmental investigation cases are also hidden from our society. Society can't get any information. I'm very troubled by this issue, and I wouldn't like to live in a country where one fine day any of us, a researcher, journalist, and photographer, just like Vakhtang Maisaya, who was a frequent guest in our studio, he was arrested secretly. I mean, this person represented a social organization. He did not work for state or bodies, and he did not get any access to national security information. And a person who works as a researcher, he can get access to the information which all of them can get access to. He was accused of this, and this mystery still remains unsolved, and of course we have a lot of suspicions about the honesty of investigation, and that's why I asked you to come here and talk this issue through. And one more point is intra-departmental investigation cases also are just wrapped with secrecy. For example, a case about Solomon Koridze, about his death, which you lawyers know well about. And there is one more topic when a person who was oppressed by state machine or law enforcement bodies, such as in village Melani, the deputy director, deputy headmistress Lamzera Kochishvili, who during the visit of president was stolen, was kidnapped, abused, beaten severely, and she doesn't even today know anything about her fault. We have a suspicion that that was committed by power structures. So I'd like to share with you and talk about the solutions in this aspect. Thank you very much. So, Liam, I think this form existed even earlier in the Constitution. And of course, we had cases before, and cases that really contained national security information. But now, all justice process, justice system is being classified. And the purpose, I think, is that society should not even have asked questions about secrecy or classification. Why do justice and law enforcement bodies have to use these methods? Of course, it's a really very important issue, and our society is not informed about what classification and declassification mean, and how investigation and proceedings were classified, and what are the responsibilities of the society in this aspect. And this concept dates back to old times. If you do something in a dark room, of course you have more freedom, and you can do whatever you do, whatever you want to do. And to counter this, there is a principle of publicity which justice should use. When we talk about the right to honest proceedings, this right means public proceedings. That means not just court process publication and principle of open door, but even investigation stage should be transparent to a certain degree, so that the society and just shareholders should have a right to double-check its objectivity, honesty, and prove something, something opposite if they don't agree. So the answer to your question is very simple. So why do justice bodies need to classify criminal cases? And practically speaking, of course, any case may contain national security information, and this part of the case, based on the state interests and national security interests, should be really classified, and no arguments and no two ways about that. But this should extend to that part of the case that really contains classified information. And how should the society be convinced that this case, for example, really contains classified information? Well, it shouldn't be declared in detail, but it should be declared what it concerns. Society should be convinced properly, but he who doubts that, he should have some access to realistic mechanisms to ask for declassification. And based on the law, shareholders should have a right to ask for declassification of the information which had been classified earlier. The same principle should extend to the case and the persons involved in the case. But the trouble is that we are not told why the whole range of cases was classified. It's impossible that everything is classified around the case. It's impossible. We are not told about the decision about the classification. We don't need to know the content of information, but at least we should be told that case case contains some security information. So in this aspect, when we are not informed sufficiently from the side that has a right to classify something, and we have questions unanswered, of course we do have a right to suspect the honesty and legality of the decision. This topic became very important. Why? Because even the lawyer was not informed about the materials around the case, and he was not given even the decision, which in no way can be classified. And the Gela was a defendant on the case, which was really declared as classified. Yes, of course, he did a very good job, and I think we should listen to him. He's got a practical experience. When he offered me to participate in the discussion, I just remembered the cases I was involved for the last several years, I mean with classification code. And I remembered 4 cases since 2007. And first, Gurchani's so-called supporters, 12 persons were arrested. Then Koridze case, who was accused of a very ridiculous thing. If you remember, Gurchiani supporters were accused of a coup d'etat. And Koridze was accused of a ridiculous stuff. He was a colleague of Vakhtang Maisai, and allegedly, well, he worked in one of the same university, and allegedly he asked one of the colleagues and asked if Maisai was either wanted or sentenced already. That was the accusation, and it was formulated that way, urging to give out state national security information. The most ridiculous is that this is not absolutely classified information. The third case was about so-called Kochoya case and explosions near the U.S. Embassy and Labour Party office. 12 of them were sentenced and 3 were wanted, and they got 30 years sentence. The last case was Operation Envery, where 9 persons were sentenced, and one of them was defended by me. And part of the prisoners, I mean, Koridze case, are released now, and only 4 are just doing their service. Of course, I can talk about that in detail, because there was nothing particularly classified, despite the fact that I just took a commitment not to give out the information. But about Envery and Kochoya cases, the two talked so much that nothing classified was left. The only classified thing was that there were no evidences. The purpose was not to publicize that. Do you think it was the only motivation, just to classify the case? Well, if we add photographer's case, I was not involved, but I know from lawyers that it contained no classification. Could you imagine that, for example, how much costs the construction of presidential palace? But it's classified, we are told. And when such things are classified, it's natural that we will have questions and suspicions. And again, I can talk about those cases in detail, because everything was told on TV for the purpose of propaganda. And defend side, of course, was bound and made to take some commitments. And there are just ridiculous things in these cases. If we talk about that in detail, just I'll really blow your minds. So, and what kind of mechanisms should we talk about? First of all, why should should justice bodies use this way? Why do they invent this form? Or it's already experienced, it's already piloted, and that's why we can classify, we can create this classification scheme so that society shouldn't even have a chance in the future to ask for declassification. It's quite hard talking about motivation because I don't share what is behind that information. It's absolutely arbitrary interpretation of the legislation, and I agree that the only reason for classification is covering up their own mistakes. This is a practice which Georgian government uses, and all branches of legislation in Georgia, and justice should not be only executed, it should be visible that it's executed. I think this formula quite well shows our worries, and a lot of countries have a conservative approach. For example, information freedom law does not extend to justice bodies, but it can be explained, unlike our country. In Georgia, information freedom law extends to justice bodies. We have more liberal approach and higher standards, and this legislation, well, has been existing in Georgia for 12 years, and we have perfect experience with issues, but quite well formulated. And there is a great danger that we may lose all this 12-year experience because the justice bodies should set a good example for other state bodies, but they don't do that. They fail to do that because they themselves, the court structures are the organs that answer journalists, that their organs would be paralyzed if journalists would ask for information and get it. I think it's absolutely inadequate and shameful step on the part of justice bodies. However, I'd like to talk more about legislation frames. We said that we have higher standards in Georgia. I'm proud of our legislation about information freedom. And in 2008, we're one of the 12 member countries, European Council, that signed official document within the framework of European Convention, and our standard means that we, Georgian citizens, have a right to get information, to know justice and truth. This is constitutional right and is supported by European conventions, and before they got this convention, we had it in our code, in our constitution. It means I have a right to get any information as long as it is not protected by more important interests. This important interest may be investigation, state security. But yes, they are referring to these motives too when they say that, the case contains classification information. Yes, now let's talk about how government should explain that. It's not an absolute right, to get information. It's limitable. And, for example, in parallel, I have certain interests which I should balance. And why do we regulate all of this with law? Because law should define what is a higher interest and what procedure should be used to balance the right to get information. The law defines that there is state, law, commercial and private information and no other categories, but there is a parallel reality, unfortunately. And for example, Parliament lately initiated law about the legislation, and in parallel, a lot of changes were being made in the Constitution. information, and that made our situation worse. For example, forbidding video and audio shooting in courtrooms, which was a serious blow not only for us but for the Georgian justice as well. And when the code defines the categories of classification, we can't go beyond these frameworks. And as we talk about the national security information, the law already defines what security information means, and I have specific lists. So, and it has its procedure, and procedure is a quite important thing. Many think that the statute is self-sufficient and does not need a procedural part. Procedure in this case, when we talk about national state security, it just has a crucial interest and importance. And why we establish these classifications and categories? Because there is always danger to cover your own mistakes. In a procedure says the following: when we think some information classified, I make a decision and I say that we should reveal the IDs of those people who made this decision and who were responsible for protecting this security information. And of course we publicize all foundations for any decision. So it doesn't happen that somebody a priori has an information and classifies it. If we talk only about mistakes, let's assume that there is a mistake and government wants to cover up this mistake through the classification of a whole case. And what could do society to regain this leverage? I mean, to get information on cases where justice bodies simply did not have more evidences and could not explain the case properly. It's I have a simple answer. We should select and elect the government which won't do that kind of thing. When we talk about justice and we bring about specific examples, what is happening in courts, even for lawyers. But before we reach the court, the information connected with investigation is not public. I will bring about a simple example. If you remember these public pictures when civic activists visited Mukhashavria police department because of the death of Solomon Kimaridze, asked to show them the place where Kimaridze fell down and died, and they were told that to go to the press center of the internal ministry and to ask for the information. And why is justice afraid of giving out such information? Because the victim did not fall off the land, and they simply wanted to cover it up. But it's the information which they spread themselves, but it's a lie, and society is not supposed to have an opportunity to double-check that. Gela said that we should elect a new government which should write better laws and execute laws better. Yes, and also conducts a policy of transparency. But here, in this case, we have bad law, and that's why just we can get access to information. Yes, for example, the law is bad too. And okay, let's leave alone classification code. I, as a lawyer, want to shoot proceedings because my protocols are falsified. I mean, the interrogation and things which was said by defendant and others are absolutely falsified when I get protocols. But I have to prove myself, and I ask for the right right to let me record. But judge, law allows me, but judge decides on that. Abroad, they are told that they also just don't allow. But then what is allowed? Abroad, the court itself records every proceeding, and when they get any application, in 5 minutes you are given this video or audio recording. When American lawyers were here, when I told them that in America you don't practice that, they were surprised. They were simply shocked. They simply said that the courts themselves record the proceedings and then give them out as required. And the more important thing is that USAID provided our court with 80 units of sound recording equipment. And the USAID declared and pointed out that not just administrative or civil court. Every court should be equipped with that, but they installed it only administration and civic. But when I ask about the criminal court, they say that it would stonewall the process, that they just said that there is secretary and the secretary just writes shorthand. We say that it may be a human factor. A secretary may simply skip something. You see, the court was closed. When they banned the video and audio recording. And statistics also show that even for journalists, court decisions are now hidden. And even protocols journalists can't get from the court. Just let's talk about that. I also appealed, the court to let me record. I have this right. I take some advice from Tamar, and I'd like to record something previously, but we are never given a positive answer. For example, once I wanted to record the audio version of the proceeding. And I remember 2010, the chairman of Supreme Court said that these thick volumes will go down to the history, and we would get a disc, and then we, of course, appealed, but we were told that in this particular case, equipment of sound recording was not established yet. But let me add, it's not just shorthand. Nobody has a right to write in shorthand, because a judge simply warns him or her, and if he or she does not obey, judge makes him leave the court. The law does not limit that, but without permission of judge, you can't write any shorthand there. But one thing is what law defines, another is the way judges behave and what procedures it offers for audio recording or stenography. For example, in Gori, one journalist was banned to write something on the palm of his hand, and the notebook was taken away from him. Law does not give this permission to a judge, but he who executes law He simply just uses arbitrary methods, and it's for our viewers. When journalist writes shorthand, now law gives a judge a right to put an end to that. But in this case, the judge behaves arbitrarily or within the framework of laws. You see, you can't argue with judge. He can make any decision. But does a law give such field of free interpretation? I think we should point out when we talk about just why we are not allowed to see the landing in Mukhashavria police department. Here we have the same dilemma. Internal ministry has its own law to use a centralized communication system, so we should only be able to address centralized the press center. You see, everything can be made legal but may not be legitimate. It's not correct that they have such centralized communication system. We know ministry should use presumption of openness. And openness presumption needs professionalism and ethics, which our state bodies don't have, and unfortunately our courts don't have it either. And if they had professionalism and ethics, if they wanted to prevent mistakes, they wouldn't have done that. At least they wouldn't have had such judges. They shouldn't behave under the pretext of covering mistakes that way. Again, we ask for just legal things of them. Based on the law, of course, until criminal case is finished, it's not public, and neither is information connected with the investigation. But we had for just a case when, after the case was finished, we were refused to get information. And in one case, the victim already was released, and certain information was not publicized because it was connected with the investigation stage. This is arbitrarily action, and we can't say that they acted within the framework of legislation. As for the transparency of legislation, one more time I say that there is a law and statutes that utilize this law and represents a source of legal interpretation. So judges can regulate how audio recordings, for example, should be conducted. For example, every court has security, and for example, you have a right to use dictaphone, but security has a right not to let you take through the dictaphone. That's why, as we have suspicion, that's why we should point out professionalism, ethic, openness presumption, accountabilities, and responsibilities of state bodies, justice bodies, and court bodies. They don't feel accountable, and they will always have an opportunity to invent a statute which would bind you. Tamar, I partly disagree, because law forbids shooting or shorthand not only in the courtroom, but in the lobby and in the yard too. So a lawmaker declared that after 1997 law, where we had complete freedom. So in the courtyard, you can't use any recording. So in the courtroom, in the lobby, and in the yard. I understand that based on justice interests, you may just limit or simply ban during the proceedings, but the yard goes beyond any limits. And when we appealed just on the point of one of the cases, I don't understand what our government should answer. How should they justify that even in the yard you can't record anything? We know that abroad, well, courts have no yards, and only here they have large territories. And number two, I have never seen that yard shooting was banned. So interviews are always given in the landing. But I have heard, I have seen the letter of a chairman of the Supreme Court where he says that the yard belongs to a courtroom, you see. So how should we make any difference here? No, lawmaker just declared it legal, and the judges in practice turned it into arbitrary decision and cover up. And they simply violate the legislation and take arbitrary decisions. For example, yesterday a lawyer talked to his customer who simply was shouting into the receiver. And the trouble was that resolution decision was one, and the text he was given was different. But otherwise you couldn't cover that. Forbidding video and audio shooting and shorthand. The purpose is quite clear, okay, but not in favor of justice. The law says that recording should be conducted only with permission of judge. So it depends completely on judge, and if judge says no, you can't record anything, because law allows him to do that. In this case, when they declared one decision, but in your hands you get a different decision, you can never prove that. This is their purpose, this is their goals, and its purpose is to cover up mistakes. Nowadays, one of the courtroom, you see, secretly wrote some shorthand, and I used it as an evidence before the Court of the Appeal. But they told me that it's illegally obtained information, and they didn't even listen to that. So they are still using such arguments very successfully, by the way. But there is some experience, for example, to send these documents, for example, to a higher organs, for example, a Strasbourg court, where for example, cases have classification code. So Leah is an expert of Strasbourg code, Strasbourg court, okay? I have a similar experience, fortunately. I know that many cases from Georgia are in Strasbourg on this issue, especially just cases containing national security information. And one case was declared as classified, while now victims are not accused of state information leakage, they're accused of swindle, and I suspect that if my customers committed swindle, on the other side, from the Ministry of Defense, we're just stupid people, but none of them was punished. And I think the purpose was to classify this case. When I asked for letting me attend the closed proceeding under the pretext that I wanted to appeal to the Strasbourg court, I was refused, and I was not given case materials, just like the lawyer who was working on this case. This is ridiculous. It's hardly possible. It's outrageous, what is going on in 21st century in Georgia. I'm absolutely sure that this is winnable case, because not a single element of this case contains classified information. But how should European Court declassifies that. Well, it's not classified case, I appeal, but I'm talking about really classified cases. But there is procedure which stipulates protection of confidentiality. For example, in Chechnyan cases, Russian government insisted 9 times, and court stepped back. And there was appeal. The Georgian lawyer Mukhashavria says about everything in conferences, and this is classified information, so they simply demanded unclosing the case. And I got a letter which writes that a court made a decision to declare the proceedings classified, and you are not allowed to make any public speech or declaration or statement. And I kept that to protect my customers. And, however, it was noted why and what was the motivation for classification of the process. However, confidentiality is not just the only thing here. For instance, some ID is not publicized, and if you explain the case reasonably, IDs would be just ciphered with some abbreviation. Of course, it concerns private life, private property rights, and not just security, state security information. It's just based on a claimant's private interest, his private life, because we know that decision against terrorists in European court. Of course, investigation was closed in Britain because of terrorism, terroristic actions, but European court decisions are open and transparent. And one thing is practice of European court, confidentially proceed, but another thing is the practice which is connected to information freedom law legislation. In 2009, European Court did a breakthrough step and recognized that information freedom is fundamental right of a person, of a human. And this is connected with the court cases. Once a parliament member initiated some claim which was not subject to appeal, but the court just decided that there was high public interest and people have right to know, and it was declared as violation of European Convention, such practice. And as for the cases connected to information freedom, there are some cases from Georgia. For example, Solomon Koridze criminal case. The information freedom law does not extend to this case, but we all admit, and even prosecutor's office and internal ministry declare that there is high public interest towards this case. But however, investigation is not being investigated as but it's about death and not about mistreatment. But that's the point here. So, officially, it's not open for us except for the information which public prosecution office publicly will declares and publicizes. But if about this case we can't get information, this may go to European Court under the motive that based on high society interest, the court should define how our constitutional rights were violated. Well, I think our discussion would have been much more interesting if somebody from justice system had come here. However, of course, it's very hard to achieve in Georgia. However, we all see the problem. And where do you see the solution or way out here? Because the situation is quite dead-end. Well, I have one idea and I'd like to share with you. I mean, representatives of civil society, and let's discuss it. Maybe Gela, as an experienced lawyer, may think about it as a naive idea, but still we shall come up with that. Well, initially I don't believe that everything is in black and white in our country. And only just elections and change of government should be the first to do. Based on that, I have an idea. Maybe we, representatives of civil society, I mean journalists, researchers and others, should create some trust group which we would equip with the mandate, I mean, high level of trust on part of the society. I don't know from which bodies, but we should ask to legitimate this trust group, I don't know, Security Council, Internal Ministry, or Prosecutor's Office. That would allow this trust group to get involved with certain cases and study the classified information. Gela is smiling. Yes, Gela is smiling, that's what I predicted. But as a result, you see, well, Gela is experienced. You know, there is a phrase from the Bible, okay? So, blessed is the one who has small mind for doubts. Yes, but, you see, we still may get some results. For example, police may be allowed to correct small faults. And if, of course, this trust group signs and takes commitment not to publish this information, I think we would have a right to get involved with Solomon Koridze, for example, case and investigation process. I mean, for example, I'm troubled by my issue, and I think him as one of the best researchers who frequently visited our studio. And together other experts, of course, he deserved more attention, and I think partly it's our fault that we were not energetic enough as we were in case of photographers. Of course, it was about one person, not five, but still, I think we can raise this issue and reach some consensus with the government. But what is so naive about this idea? I'll bring about the specific example. I told you that scientific colleague of Maesaya, basic Oboladze, well, it's the proceedings. He was accused of urging to give out state security, and when a person who allegedly urged him when he was interrogated, well, he was already free on bail, and he would go to court from home. He said that he had given the information, but it was not classified. When I asked him, he said it's public. And now just accusation, first starts interrogation, then security, and defendant authors, and the finally, again, accusation has a right to interrogate. And when I interrogated the guy, he said that there was nothing classified about that. Now the question was becoming clear that there was no crime, there was no fault. But here at this moment, Attorney General said that he got a call and he must leave the proceeding and adjourn for tomorrow, because he said he was very hurried. Of course, he hadn't got any call, but then he justified that he got a message, phone message. And of course, the judge understood that the case was destroyed and they adjourned it. And in several days, of course, the defendant admitted that it was classified, because meanwhile he was pushed, he was threatened, and he admitted the wrong thing. And the group which you are talking about, will it be allowed to see all this and publicize? I don't think so. I don't think so. And just why your group would be shown to those things? I mean, in terms of Kochoye or Enveri cases, there are 9 prisoners, and 8 prisoners simply were just set up. I think police just put into their pockets memory sticks, and you can record anything in memory stick, and they were set up just like that. The 9th defendant simply was already arrested in his cell, and he simply couldn't accuse more. But the purpose, just let me finish please, the purpose is not publicizing information. The purpose would be to make these bodies, justice bodies, to treat their cases more responsibly, and the trust group will have an opportunity to say either that until classification time is over, they don't feel it necessary to ask for declassification, or this group should declare. But why should they let you do that? They have a right to do it this way, okay? It's one of the form of cooperation, okay? Yes, of course, Mamuka provided us with this information. But idea of a trust group I like, but it should be created, in terms of realistically classified information, and not the information which a priori we know that is not classified. Things we are talking about in criminal cases and about groundlessness for closing criminal cases, it should not be the issue of the trust group. And I had the proceedings in Court of Appeal. We lost it, and we simply asked for the information how much was spent on 2011 concert, but they told us that it's classified, it's personal information. We didn't ask for exact money, I mean how much they paid to Sting, but then we appealed, and this morning we got the answer. But now, they told us that it's information about private persons, and it's classified. So it happens every time this way, and we every day write letters to public establishments, and then we have to appeal it to courts. And what was just said, it does not need trust group. Court control is the best thing man has ever invented. It may not be perfect, but we can't trust a group of private persons, except for the extremal cases where nobody has a doubt that information is classified. But our right to know must be provided for. Maybe I sound too just maximalistic, but without such maximalism, where in the country where dishonest court tells about public information that it's classified, but what maximalist requirements you have? Well, law about state national security. Well, I think we should ask for such information within the framework of this trust group. So, and I'd like to know the information. It belongs to 2011. 2008 we got information how much was spent on the concerts. When we submitted this document last year, Ministry of Culture said that they had made a mistake, and it was not public, but they still had given the information. But now they should have a right to give out, and of course we will address our Supreme Court. important thing which is important for our viewer. If information is classified based on the rules, and if it got into journalist's hands, but he who just publicizes is not responsible. Responsible is the person who had to protect this information. So if I have to protect confidentiality, no, I have to do that. In other cases, why society is able to decide? Society is able to decide, do you know, if it is informed, but unless I have information, how can I make right decision? So all this trouble leads us to the point where we become uninformed, make wrong decisions, and get consequently the outcomes. And we can't elect new government unless we have good information. It's a much deeper problem than just one criminal case clothing. However, I'm sorry about those people who are illegally prisoners now. And I think that it's a really very good idea to create some platform through which, in case of high public interest, some cases would be subject to open, proceedings. For example, cases you just named, and plus Solomon Koridze case, if the group got together with specific questions, and if these issues were discussed, I agree that when illegal action is visible, and we can see that, I guess that we should try this too, and I think that creation of such platform is a very good idea. Moreover, our government took a responsibility. There is an initiative, Partnership for Open Ruling, Open Government, which Georgia joined, and for 2 years Georgia takes responsibility what it should do to be more efficient, more accountable, and more transparent, government. But we all know our condition in terms of justice and the judiciary system, and we do know that within the framework of this initiative, government now is working on its responsibilities, and it should be subject of our negotiations. It should be based on our offers, our suggestions. So we can do that within the framework of this open partnership. Again, I said over again that this is not a decision which should be taken in a normal condition about creation of the platform. We need the platform because we need our legislative limits, but we also have doubts, and we need additional leverage to control society. Of course, we are not going to lose objectivity and honesty to use our legal ways against those decisions, but we will have some space where we will be able simply to ask questions. If the format will like that, I would personally welcome it. Of course, we will ask questions, but they should answer our questions. That's what I wanted to point out. Could you imagine who would be members of this group, even just one member, who would be trusted by government and by society too? But, I think society should trust him. If, for example, 15 persons were offered by the public, but government picked up 7, but government wouldn't pick up a single. And, you see, neutral organizations are recognized, as NGOs. NGOs are recognized neutral organizations. But for them, we NGOs who criticize the government, we are enemies for them, not opponents. And the government would say that, yes, I, for example, trust Mikhail Tavkhalidze, Levan Cholukhashvili, Levan Ramishvili, Ted Koridze from NGOs, but these people have no public trust, you see. No, we had a good precedent. I mean, campaign, it concerns you, which obtained certain results. Campaign is not over. Do you think that because of this campaign you reached that? Of course, campaign was very important, but, well, they just simply made certain steps. But only because of be it American ambassador or other international organization, they just registered in their Facebook their protest, and that was a sign to government to step back. And you see, just ambassador and organizations felt the public demand. And I agree that first American ambassador feels the public demand, and only after that our government feels that. But the reason for success was just people, active people. If we talk about a trust group, we should talk about whom public trusts, and not that government should select a trustful person. Most important, who people trust to, and who will represent people, who will mediate for people, and the foundation for success for any campaign is, again, just a group of active people, energetic people. This is the idea which spontaneously just was generated in our discussion. I think Mamuka said about that. And of course, your feedback is, of course, logical and instant. You know, the reality which just each of you just described needs some solution, of course, because practically I wouldn't become a hostage of my words, but I think we're living in the conditions of really classified justice. Today we talked about that in our discussion in our studio. Tskriala Shermadini, Gela Nikolaishvili, Tamar Gurchiani, Mukhashavria, and Mamuka Kuparadze were guests of Studio RAM. Of course, your feedback, your ideas would be very important, not only about, not only because of this description of the situation, but just to go out of the situation. And you can just ask questions in our website, www.studiored.org, where you can see the video recording of our program. Thank you, and see you next time.